Welcome to this question and answer session with Bruce Thornton, independent consultant and trainer. Bruce developed the risk model several years ago with David Paul of Gwynedd Council. Bruce has introduced the risk model to authorities across Wales and England over the last 10 years. In this conversation, we focus on threshold, its definition and how we assess thresholds. Bruce, we hear the word threshold used a lot. What is threshold?
What we mean by threshold is the likelihood of a child suffering significant harm. This is a legal definition. It comes from various parts of the Children Act 1989. For example, it's what underpins a court's order to remove a child from their family. In child protection, in Section 47, it is the likelihood of significant harm that places a legal duty on a local authority to investigate. That's why you hear people talk of a Section 47 inquiry. The threshold can be thought of as an on-off switch. Something is either below or above the threshold, a little like a switch. It can't be a little bit on and a little bit off. This threshold is a judgment about whether the child is suffering or likely to suffer significant harm. It is an important judgment as it gives the state the right to interfere in the private lives of families. And, of course, if the threshold isn't met, it is a matter of a fundamental right to privacy for families from the interference of the state. Ultimately, the only person who can make a final judgment about significant harm is a judge during court proceedings. However, the law places duties on local authorities to investigate. That's why social workers test whether the evidence on the balance of probability gives them reasonable cause to suspect the likelihood of significant harm. If so, they have duties to investigate and act, and if not, they don't and cannot take legal action under that part of the Act.
Thanks, Bruce. So it's a threshold and it means significant harm. What is significant harm?
Well, actually, it's more than suffering significant harm now. The threshold is that a child is suffering significant harm now, or that significant harm is likely in the future. So it is about now and also how things are likely to be in the future unless something is done. It is best to explain significant harm by breaking it up into its two parts. You have harm, and then what makes the harm significant. In the Children Act, the definition of harm is that a child is suffering ill treatment, which is abuse or impairment. Impairment means the impact of their needs not being met for their health or development. Impairment can also mean the effect of seeing another person abused. An example would be the emotional impact of seeing or hearing domestic violence. In law, significant is only defined by comparing the child in question with what you'd reasonably expect of a similar child. That isn't very clear, so over time, case law has clarified significant harm. Case law has described it as being something important, considerable, unusual, or noteworthy. It has been defined as having two main elements. These are that the harm is serious or severe, and secondly, that it has meaning. I think there are two quotes that tell us where the lawmakers really wanted the intervention of the state in private family life to be pitched. If you consider these two quotes, the courts are not in the business of providing children with perfect homes. And secondly, society must be willing to tolerate very diverse standards of parenting, including the eccentric, the barely adequate, and the inconsistent. Some children will experience disadvantage and harm. So even if children suffer harm, the courts should not always intervene. Another statement by the judiciary refers to the concern that over time, the courts, through best intentions to help children, have started to deal with lower level cases. The Children Act 1989 was set to deal only with high-level abuse cases, but are increasingly drawn into lower-level cases. There is a concern that the courts are drawn into what has been termed social benevolence, that they want to help children in situations of adversity. Of course, that is commendable, but the law was never created to interfere in the human rights of families and their rights to privacy. So, society has to be willing to tolerate very diverse standards of parenting, including the eccentric, the barely adequate, and the inconsistent. It mentions that, as a consequence, some children will experience disadvantage and harm, and that it is not the role of this legislation to spare children for the consequences of defective parenting and fallible humanity. When we bring all these together, harm is a child being ill-treated and is impaired. And for this to be significant, it would also be severe or serious harm, it would be considerable, it would be unusual, and it would have additional meaning. When we consider all of these, we recognise that significant harm threshold is set very high. It's not just normal parental failure. This is reinforced in other case law that indicates for that threshold to be met, a child has to be positively harmed by the failure of family life or exploited by others outside the family.
Bruce, you mentioned that the threshold is high. It also seems to me that the law doesn't really define it, and it is tested in case law. If that's the case, it seems to me to be really difficult to prove. So, how do practitioners assess risk of significant harm?
If I take you back to the Baby Peter case, in the investigation that followed, Professor Monroe referred to 10 risk principles. One of the key messages was that social workers should not be judged by the outcome of their decisions, but by the quality and consistency of decision-making. What this means is that you will never know what will happen in a case, but every decision taken should be of high quality and consistency. The challenge for practitioners is how do we achieve this consistency and quality? A number of local authorities in England and Wales have adopted the risk model developed in Gwynedd Council to help practitioners undertake risk assessments. I have seen in casework and evaluations I've undertaken in those authorities that risk assessments are better and more consistent once the risk model was adopted. The risk model has a risk assessment tool that was designed to take the legal components I've mentioned into consideration and integrate these components into the records assessment and analysis.
Bruce, you've explained the use of the risk model to assess threshold. In day-to-day child protection, where do we see this issue of threshold appear, and when do we need to assess it?
This is always a fascinating question. People think of risk assessment as being something special or once in a while. However, every day when a call comes into social services, this threshold is considered. Of course, for new referrals, there will be some risk assessment. But also think of new information coming to a social worker about an open case. They are always considering, is this new information a matter that may now indicate a risk of significant harm? So, we assess risk informally all the time, on new referrals, on information on open cases. And of course, there are formal situations where the threshold assessment is presented in a structured way. The first time in the child protection process is during a Section 47 inquiry and preparing reports for conference. Other examples will be any matter progressed to legal proceedings. Some local authorities insist on seeing the risk assessment used in Section 47 inquiries or reports to conference or in submissions to public law outline panels. Some authorities use the Stage 1 risk screening in all supervision discussions to formalise this checking for significant harm on an open case. Over time, practitioners who regularly use the formal procedures can use these structures in their informal decision-making. Practitioners become more confident and clear in their decision-making.
Bruce: I think this can be difficult for other people involved in the child protection process to feel confident in this area or feel they can contribute. What do you think?
Interesting. Remember that anyone who goes to a child protection case conference is actually asked their view about the threshold of significant harm. But I appreciate it as a difficult area. At the end of the day, the law places a duty on local authorities to make inquiries, and at the end of these, it is a manager in social services who makes a decision about what happens at the end of a Section 47 investigation. One thing that is difficult for agencies is that we often get mixed up with the idea of trying to help people. So, when we check threshold in a case conference, we are asking, is this threshold met or not? We are not asking, does the family need help? Or, this family is really difficult to engage, and if we use child protection, we can force them to accept help, and that will be good for the children. That's not the decision that the conference needs to take. Remember, the threshold is about using a very powerful legal power that undermines everything in society about the rights of families to private life. If we have met the threshold, we are saying this child needs protecting and we can legitimately intervene, whatever it takes. If we haven't met the threshold, it is the right of a family to retain privacy and make decisions about how they live and raise their children. We cannot legally intervene without the threshold being met. Remember the comments of the judiciary. We are not in the business of providing children with perfect homes, and society must be willing to tolerate very diverse standards of parenting, including the eccentric, the barely adequate, and the inconsistent. Some children will experience disadvantage and harm. These are heavy burdens to carry. We need to equip ourselves to be able to make good quality decisions and lawfully exercise our powers. Practitioners other than social workers should take advantage of opportunities to familiarise themselves with the risk assessment tools so they can understand and contribute to the child protection process. I think this could help us all to understand how threshold is assessed and the basis for decisions in child protection conferences. I think the last point I want to make is that one of the frustrations for other agencies is submitting referrals about a family that worries them and these not being accepted by social services. Remember, if you're submitting a child protection referral and have no consent from the family and want social service to investigate, then what you are saying is, in my opinion, as a health visitor or teacher, I am suspecting significant harm. And if so, social services will look to see if there is an indication of significant harm in order to justify further inquiries. So, given what we've discussed about the legal threshold being so high, this is what your referral needs to indicate and the evidence for it. Think carefully about what you include in your referral to assist decision making. It's on your evidence that the decision is made to make further inquiries. Most often, referrals are not accepted as child protection as there is no evidence submitted to indicate concerns about significant harm. And when I looked at these referrals, when there is a challenge to the question of social services' response to a referral, I usually find that the referral does not provide the kind of information or evidence that indicated it was child protection. So, when making a child protection referral, remember you're reporting concerns about significant harm, not asking an agency to assess to see if a family can be helped.
Thanks, Bruce.